Hello, and thank you for joining us for the fourth episode of the Practical Patent Practice webinar series. This episode will discuss docketing post-issuance deadlines for U.S. patents. This is the last episode in a four-part series. The first three episodes are available online on the SLW Institute on the SLW website. A recording of this webinar and the slides will also be made available to all registrants. Feel free to enter any questions using the Q&A feature in the Zoom menu. Time permitting, they will be addressed in a Q&A session at the end of the webinar. We invite you to follow Black Hills IP and Schwagman, Lundberg, and Wussner on LinkedIn to see news about other upcoming webinars. And with that, I'll turn things over to our moderator.
Thank you, Michelle. Welcome, everybody. I'm Ann McCrackin. I'm the president of Black Hills IP, which is a IP support services technology company. We focus a lot on automation, particularly docketing automation. I'm also a patent attorney. I've been practicing for many years, and I am an adjunct professor at Franklin Pierce School of Law. Today I have with me two great panelists. I'd like each of them to give a little bit of their background. Z, let's start with you.
Hi, all. Welcome to our fourth and final docketing episode of the series. My name is Zhakalazky Carrion, and some of you know me as Z. I've been at SLW for almost 17 years. I started here straight out of school, law school, and have been here ever since then. I've been managing the docketing department for 8 years now. And I hope you enjoy what we have prepared for you. And if you missed an episode, I encourage you to go check it out. It will be worth your time.
Thank you, Z. And Ellen.
Hi, I'm Ellen Franco. I'm the docketing manager here at Black Hills IP. I've been with Black Hills IP for 6 years and have been managing the docketing department for 3 years.
Well, thank you both, Ellen and Z. I appreciate the time you've given to this program and for being here today. Before we get started, it's always helpful to have a little bit of understanding of who is in the audience, and a couple polling questions that I'd like to bring up just so we get a sense of who's participating today. So the first question is, what is your primary role in your organization? Docketer, paralegal, attorney, manager or administrator, IT, or other? And if it's other, if you wouldn't mind putting in the chat window what other is, because maybe I'll update my categories for future programs on this polling question. So I'll give you a few seconds to put your response in. Michelle, I'll let you kind of watch and just let me know when you think we've got most of the responses in, and it's time to, when you want to close the poll. Okay, so the majority of the people are docketers. We have 35% of the audience docketers, 26% of the audience are paralegals, and then quite a number of attorneys as well, 18% attorneys, a few managers and administrators, and a few people that selected other. Okay, 2 more questions. Let's go to the next polling question, Michelle. Who does your US patent docketing? Are you handling this with an internal docketing team that's dedicated to docketing? Do your internal paralegals do this work? Do you use an outside vendor? If you're a corporation, does your outside counsel just update your system for you? Maybe you don't have an internal docket, again, likely a corporation, or other. And if you're selecting other, if you explain that one in the chat window as well, that's helpful for us for future programs. So I'll give you a few seconds So we can see just the context, because this program's focused on US patent docketing, this whole series has been. It's interesting to see how the work is done by the organizations that are tuning into this program. All right, so the majority of the audience has their own internal team that's dedicated to docketing. That is 63%. And then a good number, 23%, have their internal paralegals also do docketing. And then the numbers get quite small. One uses an outside vendor. One organization must be a corporation and they have outside counsel update their docketing system. A couple people have no internal docket and a couple people in the other category. All right, then just one last one that I always find really interesting. So Michelle, let's go to the next question. What is the primary docketing system that you use? Are you using a NACWA, AppCall, CPI, Foundation IP, Improtech, IP Folio, IP Manager, Memotech, Patricia, or other? And again, we put the other in the chat window. And I know there's more systems than this, but our polling software only gives us this many choices. So we had to drop a few from the list. I imagine there'll be a few people with other as their selection. Okay, let's see the results. All right, the two most common represented are CPI systems and Foundation IP systems. Then after that, it goes to, looks like AppCall next, and then a NACWA. After that, Improtech, IP Folio, and Memotech with smaller numbers. But by far, we have the majority of the people are either CPI users or Foundation IP users. Okay, that's really helpful. I appreciate that. Let's jump into the program and go to the next slide. So I like to start with the big picture, just to step back for a second. Some of you have been on the other 3 webinars in this series, but probably not everybody. So a real quick overview to just get ourselves oriented. This webinar series has focused on docketing for US patent prosecution. And we went through the program in chronological order based on the timelines that you would follow through the life of a patent application. The first program, episode 1, focused on initial filings and bar dates, priority dates, foreign filing deadlines, those types of things at the very left side of this arrow. That would have been in the first program. Then the second program moved into the after the application was filed, the initial things like formality requirements, docketing those, docketing non-final office actions, and the initial examination. That was in episode 2, up through non-final office actions. Then episode 3 went into deadlines for final office actions, allowance, and issuance. If anybody attended that program, you know that was jam-packed with a lot of information. We had a lot in that one. So today we're at the far right side of this arrow, which would seem to be, based on this graphic, the end of the process when we start talking about post-grant deadlines. And I think a lot of people, particularly as an attorney, you kind of think once the application or the patent's granted, you're done, you move on to the next thing. But from a docketing standpoint, there's really still quite a number of deadlines that need to be tracked related to that particular patent once it has granted. And that's what we're going to be focusing on today. So Michelle, let's go to the next slide. So the objectives for today's program are for you to be able to identify the required and the optional events in the life of a patent that happen after a patent issues, and then understand what deadlines are associated with those events. And then finally, for fun, we're going to have a number of polling questions to test your knowledge of the post-grant docketing. And just to make it fun, I believe there's 6 polling questions that we've labeled in the slides as test your knowledge. And Anyone on this program who answers all 6 of the Test Your Knowledge questions correctly will receive a free Famous Inventor bobblehead from Black Hills IP. So if you try really hard to get those all right, we will contact you within a week of this program and give you a choice of a Famous Inventor bobblehead. That would be from one of the ones we currently have in stock. We've got 5 or 6 different ones in stock right now. And as long as you live in the United States, we will then ship that to you. So let's see how many people can get all of these questions right. Let's go on to the next slide. So high level overview, the way this program is going to be organized. First, I'll talk about patent term and expiration dates. Then we'll talk about deadlines that are required post-grant, and then the deadlines that are for optional procedures and proceedings that you may docket post-grant. So those are the 3 main categories that we'll be focusing on. Let's go into the next slide. And that's just a transition slide. So let's move on into the next one. Okay, so one of the first things that comes up after the patent grants is, what is the term of a patent? For US utility patents that were filed after June 7th, 1995, there's a 20-year term. Basically, the term is 20 years from the earliest non-provisional filing date. That's written there a little more wordy, but that's basically what that says. Your US patents, most of them today are 20 years from the earliest non-provisional filing date. Earliest non-provisional US filing date, let me clarify that. The term prior to that was 17 years from issuance. There's not a lot of patents around anymore that still have that old 17-year term. So it's mostly 20-year terms. Design patents have a different term. US design patents that result from an application filed after May 13th, 2015 have a 15-year term from issuance. So with that, let's go to the first Test Your Knowledge question. So next slide, and then let's pop up the polling question. So the first Test Your Knowledge question is, what is the term of a US design patent that was filed before May 13th, 2015? Is it 14 years, 15 years, 16 years, or 17 years from issuance?
And it looks like we have a few more answers coming in here, so we'll give it a few more seconds.
Yep, we want to give everybody a chance at this.
And it looks like our answers are holding steady, so I will go ahead and end polling. And here are the results.
Okay, so the correct answer is 14 years from issuance. So 53% of the audience got that right. The term for a US design patent that was filed before May 13th, 2015 is 14 years. The patent term changed in 2015 for design patents. So those older ones have a 14-year term. Okay, let's go to the next slide. So that's the term of the patent, but then the next thing that comes up is usually expiration dates. How do you actually determine the expiration date of a patent? Well, the answer is it's complicated. There's no document that you get from the patent office that calculates the expiration date for you. There's nothing in PAIR that has it. And there's a lot of factors that have to be considered when you are calculating an expiration date of a patent, including, as we just showed, the type of application, because a utility patent has a different term than a design patent. Also looking at the filing date and the grant date. Again, design patents are calculated from the grant date, but utility patents are calculated from the filing date. Then whether or not there was a domestic priority claim, if there were any patent term adjustments or patent term extensions or terminal disclaimers. And then you might think you have it all figured out, but don't forget to check the maintenance fees, because sometimes you've figured out what the expiration date of the patent is, but then you don't realize that the party who was responsible for the maintenance fees decided to let the patent lapse, and maybe it is has lapsed due to non-payment of maintenance fees. So the determination of the actual expiration date of a patent is complicated, and normally you'd want to pull in an attorney to help with that determination, particularly when you have terminal disclaimers involved. But from a docketing standpoint, from a what I'll call an estimated expiration date standpoint, a lot of the docketing systems today do some basic calculation of the expiration date, and they'll do that based on the filing date, the priority date, and the PTA if the system has a field where you enter the patent term adjustment. And that's a pretty good estimate to have if you're just looking for a general idea of what the expiration date is. Now, the good news is if you are going to try to figure out the actual date, the US Patent Office has a really handy patent term calculator available for free. So Michelle, let's go to the next slide. I don't know if everybody's aware of this, but on the PTO's website, there's a downloadable, they call it a patent term calculator. It's basically a spreadsheet that has the calculations built into it and walks through a set of fields that prompt you for the particular things that go into a patent expiration date calculation. And it's really slick. So I'll show you on the next two slides what that looks like. And I encourage you, if you weren't aware of that, to go and download it and have that, because it's a really very useful tool. Another tip that I'll give you, if you have general questions about patent term, not specific calculations on a particular patents dates, but just general high-level questions about how certain things factor into patent term and patent expiration. A wonderful resource at the USPTO is the Office of Patent Legal Administration. They're another resource that's not real well known, but these are my go-to guys when I have a really tricky question about the patent rules. So the Office of Patent Legal Administration is staffed by attorneys. They're the group that writes the rules when there's proposed rule changes that are going to be pushed out. And they really are the experts behind all the rules and practices at the USPTO. So save that number. When you have really tricky questions, that's a great resource to call. Okay, let's take a look at what this patent term calculator looks like. So next slide, Michelle. This is just a screenshot that I took from the when I had that spreadsheet opened up. So this is built into a simple Excel spreadsheet. It has fields that that you fill in for the filing date of the patent, whether or not there's a domestic priority claim. If so, what's the earliest effective filing date? Also, I forgot at the top, it asks whether this was a utility patent or not. And the dates are in here are ones that I just filled in just as an example. So I said the filing date was January 1st, 2019. The grant date was October 1st, 2021. I said there were no patent term adjustments or patent term extensions and no terminal disclaimers, but if there were, you'd fill that in. And then let's go to the next slide. So then I couldn't get this all on one screen. This would just be scrolling down in the spreadsheet. So scrolling down in the spreadsheet after you put all that information in, it actually also is really handy because it tells you when your maintenance fees are going to be due. So for my example, my 3 times for my maintenance fees are going to be in 2025, 2029, and 2033. But most importantly, at the very bottom, by that yellow highlighting and the red carets, is the expiration date for my patent. So super slick tool. I think it's a great resource and just wanted to share that with everybody because it's really, really, really useful. All right, next slide. And then let's go on to the next slide after that. Okay, so first, I want to talk about the deadlines that are required for any patent. So these are deadlines you have to docket. These are required deadlines for a US patent. And there's not many. There's just the maintenance fees. And it reminded me of the quote that I'm sure many of you have heard, that in this world, nothing is certain except death and taxes. Well, apparently that's true in the life of a patent too, because death would be the patent's going to expire. We just talked about expiration dates. And then taxes, which is basically what a maintenance fee is. So even in the patent world, that's the one thing we know that we're going to have is our maintenance fees. And actually, by the way, I didn't know that that quote was from Benjamin Franklin. I don't know if you knew that, but he said that in 1789. So there you go. All right, let's talk a little bit about maintenance fees. If you're newer to this practice, and Michelle, let's go to the next slide. If you're newer to this field, maintenance fees are required to keep in force all utility and reissue utility patents in the United States. They are not required for design patents or plant patents, though, just for utility patents. And a maintenance fee is a fee that has to be paid in all utility patents, like I said, to keep that patent in force beyond the 4-year point after the patent grants, the 8-year point after the patent grants, and the 12-year point after the patent grants. You know, many organizations will have an outside service manage their maintenance fees and their annuities. So the foreign taxes that are due are typically called annuities. Many organizations will have an outside service that will manage all of those payments to make sure that they're done and nothing's missed. So there are third-party vendors that do that type of work, and Black Hills IP has a sister company called Black Hills Renewals that also does that kind of work. Okay, let's go to the next test your knowledge question. Ellen, I'm going to turn this over to you to throw the next question out there.
Okay, for this test your knowledge question, what is the earliest date that the first U.S. maintenance fee can be paid? Anytime after grant, 2.5 years after grant, 3 years after grant, or 3.5 years after grant?
And the answers are coming in. Okay, so the answers are slowing down. We'll give it 5 more seconds. And I'll go ahead and end polling.
Okay, so 3% of you said anytime after grant, 17% of you said 2.5 years after grant, 26% of you said 3 years after grant, and 53% of you said 3.5 years after grant. And the answer is 3 years after grant.
So Ellen, I'm going to jump in for just a second. I can see why a lot of you said 3.5 years after grant. Ellen's going to talk about that in just a minute. But the key part of this question was, what is the earliest date that the first maintenance fee can be paid? So law professor, question structure is important, reading questions is important. And just wanted to point that out, that earliest date is the key thing to focus on here. So Ellen, I'll let you talk about this.
Okay. Let's move to the next slide, Michelle. So what is the PTO deadline to docket for maintenance fees? Maintenance fees are due at 3.5, 7.5, and 11.5 years from the grant date of the patent. There is no surcharge for payments made during the 3 to 3.5 year window, 7 to 7.5 year window, or the 11 to 11.5 year window. Is the deadline extendable? Yes, but there is a surcharge for payments made during what we call these grace periods, which is the 3.5 year to 4 year mark, 7.5 to 8 year mark, and the 11.5 to 12 year mark from the date of issue. If the maintenance fee is not paid within the first 6 months of the year in which it can be paid, a maintenance fee reminder will be issued. And on the next page, we have an example of this maintenance fee reminder. In that first paragraph, it talks about you missing the maintenance fee and that it can still be paid with a surcharge within 6 months from the date it was due. And then in the second paragraph, it notes that if you do not pay this maintenance fee with surcharge, the patent will lapse.
So Ellen talked about the windows, 3 to 3.5 year window, for example, for the first payment being due. And, again, going back to that polling question, not only was it a test your knowledge question, but I wanted to use it to get you to think about how you docket maintenance fees. Do you just put the 3.5 year date on the docket, or what do you have leading up to that? So knowing that the earliest date that you can pay, you can't just have the patent granted and pay all 3 of them and be done with it so you don't have to worry about it. You cannot make that first payment until 3 years after the grant date. And then it has to be paid by 3.5 years if you don't want to have to go into the grace period and pay an additional fee. So what's that mean for your docket? It probably means that you start having something show up on your docket as early as that 3 year date. And then whether you put those on as reminders or what you call them, that's up to you. But you probably start having those docket deadlines showing up on people's docket at the 3 year date. The 3.5 year date is the date that you really want to pay by. But then those deadlines can roll into that grace period, and you have to indicate that 4 year date, 6 months after the 3.5 year due date, that 4 year date, it's an absolute hard deadline. After that, the patent's going to lapse if you don't pay that fee. So it's important to think about that window and how you structure your actions or activities and the due dates within those activities. Okay, thank you, Ellen. Michelle, let's go to the next slide. So that was the one thing that you have to docket. You have to make sure you docket when a patent grants. Now we're going to move into these optional things that you might docket. Some docket systems might launch these automatically. So let's go to the next slide. The optional deadlines that we're going to look at in today's program are the deadline to request reconsideration of a patent term adjustment, the deadline to file a request for a certificate of correction, the deadline for a reissue application, and the deadline to file post-grant review. Now, one of the things that struck me in preparing for this program is that these deadlines are not being triggered by a document coming into your docketing department. Now, why does that stand out? Or at least why did that stand out for me? Because for me, in the last 3 webinars that we've done, we've structured them so we've shown you the document, we've shown you the language in the document that tells you what the due date is, and you know what to watch for in your docketing department, because when that, let's say, deadline to respond to an office action gets docketed, it's being triggered by a document being received, and then somebody knows they have to add that deadline to the docket. But what's striking to me and is a difference is in this post-grant stuff, there's no document coming through to tell the docketing department that these deadlines need to be added to the system. In most cases, because of that, what happens is these deadlines launch when you add the grant date to the record in the docketing system. There will generally be some kind of country law behind the scenes that's triggering these post-grant dates. So again, I think that's important from a process standpoint, though, because When you think about quality control, you think about things like that. Again, on deadlines that come before a patent grants, if you have a traditional quality control process in your firm or your organization where document comes in, first person dockets it, the second person does a second eye quality review, it's usually because that document is being routed through a workflow and it's triggering those things. So here, if these deadlines just launch because you added a grant date to the system, what's going to trigger the double check to make sure that they did launch, to make sure that they're correct? Something to think about for the workflow and the process in your department if you're anything more than a department of one. Hopefully if you're a department of one, then you know to go double check. So anyway, I find this workflow and process stuff interesting, and this struck me as being a little bit different, and I wanted to comment on it. Let's start drilling into these individual documents now. So let's go to the next slide. All right, the first is a request for reconsideration of a PTA. PTA stands for patent term adjustment, if you're not familiar with it. It is basically a day-for-day extension that is available to the applicant if their application was filed on or after May 29th, 2000, which pretty much most of them we're dealing with today are. Then if they're in that, if they're eligible for PTAs, then the idea here is if the patent office delayed in the prosecution of your application, you are losing time on that 20-year patent term because your 20-year patent term is calculated from the filing date. So the longer that it takes to go through prosecution and get a patent granted, the more of that 20-year term that you have to enforce your patent gets chewed up and used up by prosecution. So if the delay was on the part of the patent office and outside the control of the applicant, then the patent office will offset that with a day-for-day extension beyond that 20-year term for certain categories of delays that have been defined in the rules as being eligible for patent term adjustments. So that's the idea behind a patent term adjustment. A patent term adjustment, the amount of the patent term adjustment is calculated by the patent office. So think about that, right? They're the ones enforcing things that are due to their, errors. So sometimes they don't always calculate it right. It's not intentional, but they don't always calculate it right. So what you want to do is check to make sure that they didn't make a mistake in their calculation. The amount of the PTA that's calculated by the patent office can be found on the issue notification document, or in PAIR, there's a tab called patent term adjustments, and then also on the patent grants on the patent itself. If you want to request reconsideration of that patent term adjustment because you think there was an error, then there's a process for doing that. And Z, let's go to you because I think you have another test your knowledge question, right?
Yes. So I know most, if not all of you, know that we have 2 months due date from grant date to file a request for reconsideration of PTA determination. But how many of you know it's extendable? Now, who is ready to get their knowledge tested again? Let's see if you know the response to the following question. How many months can the deadline to file a request for reconsideration of PTA be extended? 2 months, 3 months, 4 months, 5 months, or none of the above? Submit your answers. And Michelle, let us know whenever it's kind of getting there so we can start reading responses.
Will do, and the answers are coming in. So we'll give it a few more moments. And it looks like the answers have slowed down. So I'll give it a few more seconds. And I'll go ahead and end polling. And here are the results.
Okay, so 14% said 2 months, 7% 3 months, 11% 4 months, 27% 5 months, and 41% said none of the above. And the 27% was correct. It's 5 months. So if we can go to the next slide. And this deadline, so the PTO deadline to docket is 2 months from the grant date, as I had just mentioned. And this deadline is extendable up to 5 more months. So just please keep in mind, you have a total of 7 months from grant date for filing a request for reconsideration of PTA determination. But this 7th month is a final deadline. And you're not going to be receiving a notification from the PTO regarding the PTA reconsideration. So things to keep in mind regarding PTA.
You know, it's really interesting to me, those poll results, that the majority of the audience thought that the deadline was not extendable. And that's because for many years, I thought that deadline was not extendable either as a patent attorney. And it wasn't until I got into the docketing business that I learned that, hey, that is extendable. So I think that's a common misconception that's out there. And we certainly saw that in the polling results here too. But it definitely is extendable up to 5 months. And you should take a look at your docketing rules to make sure that the way you're docketing it also reflects that, in case you have a situation where you don't get that determination done in the initial 2-month period. Okay, on to the next one. Another common one that most people are probably reasonably familiar with is certificates of correction. So after patent issues, you can petition to correct what would be categorized as clerical or typographical errors that are minor in nature, and have those corrected. There's a small fee to do it if the error was on the part of the applicant. There's no fee if the error was on the part of the patent office. And usually these errors are identified by some kind of a formal process to proofread the issued patent. So often the patent grants and the workflow is you proofread the issued patent, and then depending on what the results of that proofreading are, you make the determination of whether or not you want to file a certificate of correction. Okay, Z, I think you have a test your knowledge question on this one too, right?
Yes, I do. Let's test your knowledge once again. Let's go to the next slide. So the question is, dun, 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 what is the deadline for filing a certificate of correction? 6 months from the grant date, 1 year from the grant date, 2 years from the grant date, or none of the above? Make sure you start submitting your questions, responses.
You know what? I'm so sorry. I think we might have to skip this one.
Oh, shoot.
Okay.
All right.
Well, I guess you just get the answer, and the response is none of the above. And why is that? Like Anne mentioned before, this is an optional due date. So let's go to the next slide. And there isn't really a deadline, but what is a suggested practice to do is docket a deadline to proofread the patent 1 month from the grant date, and then docket a deadline to file a certificate of correction request for 2 months from the grant date. Now, one of the things that we do at Schwegman is we have FIP, and what you do, it just depends on the docketing system that you're in. And how we do it is, once that original letters patent is received, we have an outside vendor that does our proofreading. And if errors are found at that time, then a COC request is docketed. And like mentioned in our question prior, is there isn't a deadline to be docketed, therefore there's no deadline to be extended.
So Z, you talked about using a outside vendor to do patent proofreading. And I think that's another practice that's interesting. There's a wide variation on whether people proofread at all, whether they do it internally, or whether they use outside vendors. So I'm just, again, curiosity. Let's go to the next polling question. Michelle, do you proofread your issued patents? Let's see what the practice is with this audience. Do you do it for at least some of your clients internally? Do you do it with an outside vendor? Do you not do it at all? Or maybe, I don't know what other would be, but maybe there's some other response there that you'd want to share.
And I see the answers coming in. And we'll give it a few more moments. And I'll go ahead and end polling. And we'll share the results.
All right, so just a hair under half, 49% proofreads internally for at least some of their clients. 18% use an outside vendor. 20%, that's a pretty big number, does not proofread their patents at all. And then 14% in other. Okay, let's go on to the next slide. All right, so most of you have probably heard of PTAs and COCs. That wasn't entirely new. But a lot of you may not have dealt with reissue applications. And I have to say, in over 20 years as an attorney, a patent attorney myself, I've never filed a reissue application. So these are less common, but these are one of the things in the category of optional deadlines for patent after it's granted. So a reissued application is an application that's used to correct an error in the patent. So you basically go back into prosecution after that patent has been granted. But it's not any error. This is when you have a more substantive error, an error that would deem the patent either part or wholly inoperative or invalid. So, you know, in comparison to COCs, where the errors that you can correct with certificate of correction are minor clerical and typographical errors, the common types of things that often are a reason to file a reissue application are the substance of your claims are too narrow or maybe too broad. The application itself, the specification, contains inaccuracies. The applicant failed to or incorrectly claimed foreign priority, or they failed to make reference or incorrectly made reference to prior co-pending applications. So these are bigger problems, and this is what you would use a reissue application for. So, Ellen, you've got a test your knowledge question created for reissue applications, right?
I sure do. Okay, this test your knowledge question is, what is the deadline to file a reissue application enlarging or broadening the scope of the claims? 9 months from the grant date, 1 year from the grant date, 2 years from the grant date, or none of the above?
And the answers are coming in. And we'll give it a few more moments. And I'll go ahead and end polling.
Ellen, I'll let you do the results, and then I want to comment on the structure of the question again before you go into the next slide.
Okay, 8% of you said 9 months from the grant date, 10% of you said 1 year from the grant date, 69% of you said 2 years from the grant date, and 13% of you said none of the above. And the answer is 2 years from the grant date.
And it looks like people knew that one. And the key part of this question was the aspect of an application enlarging or broadening the scope of the claim. So covering more in some fashion than what it originally did. Okay, so I just wanted to point that out. Again, teacher and me has to come out here and there. So back to you, Ellen.
Okay, so what is the PTO deadline to docket for a broadening reissue? The deadline is 2 years from the grant date of the original patent if the scope of the claims will be broadened. There is no deadline to docket for a non-broadening reissue. Is this deadline extendable? No, the 2-year deadline is not extendable, and there is not a PTO notification regarding this 2-year deadline.
Okay, good. Let's go to the next slide. All right, the final thing that we're going to talk about today in the category of optional deadlines is the deadline to file a petition for post-grant review. So post-grant review, if you're not familiar with it, is a trial-like proceeding that's conducted by the PTAB, and it's to review the patentability of one or more of the claims in the issued patent. Post-grant review process begins by a third party filing a petition. Now, I included this one intentionally because, again, there's an interesting process thing to think about here. When we talked about, for example, PTAs, certificates of correction, broadening reissue, those are all things that are being filed to address something about the patent that you've been docketing, the matter that you're docketing, right? This is also to address something about the patent that you've been docketing, but it's not something that the law firm or the attorney with power of attorney is going to be filing the petition for. So it's not a due date for the user of the docket that you're managing. This is a due date for a third party, somebody who's going to challenge your company or your client's patent. And so it's a little bit different context. It's a date that's going to go onto your docket, but it's not a date for the attorney who's responsible for handling that patent to do anything or to take any action. It's more of a, I call it almost a monitoring type date, where it's there because you know it's a date that somebody else might take action. And if nothing happens by that date, then, you know, breathe a sigh of relief. Nobody's challenging a patent, this patent, at least under the post-grant review process. So a different context here, and I wanted to just highlight that. I believe we also have a test your knowledge question for post-grant review as well.
Yes,
This will be their last test your knowledge question. Drum roll. Hopefully we'll have a lot of people that have responded correctly to all of our questions. And Michelle will be crazy busy sending prizes and job offers to the winners. Okay, just kidding. Winners will be getting a cool inventor bobblehead though. And winner, winner, chicken dinner. No pressure to get it right. The question is, and Ellen, the mic is yours.
what is the deadline to file a post-grant review petition? 3 months after the patent grants, 9 months after the patent grants, 1 year after the patent grants, 2 years after the patent grants, or none of the above?
And the answers are coming in. And they're slowing down, so I'll give it a few more moments. Okay, I will go ahead and end polling. And here are the results.
Okay, 4% of you said 3 months after the patent grants, 43% said 9 months after the patent grants, 14% said 1 year after the patent grants, 16% said 2 years after the patent grants, and 24% said none of the above. And the answer is 9 months after the patent grants. Okay, next slide, Michelle. So what is the PTO deadline to docket? The PTO deadline to docket is 9 months from the grant date. This deadline is not extendable. And again, there's no PTO notification regarding this deadline to file post-grant review.
All right, let's go to the next slide. All right, so hopefully with what we've presented today, you're now able to recognize and be aware of these required and optional events that happen after a patent grants, and you understand what the deadlines are that are associated with those events. And we'll tally up the results of the Test Your Knowledge polling questions. I hope we have a number of people that got them all right, and anybody who did get them all right, we will reach out to you and give you a choice of the bobbleheads that are available and get your address to see where you want to have them sent. Next slide, Michelle. I want to point out a webinar that's coming up in a couple of weeks that I think is really interesting, and I encourage everybody to sign up for this one as well. We're going to have some reflections on how automation and artificial intelligence are changing professional career opportunities in the IP field. So, you know, in particular, the traditional role of a docketer or a paralegal, what does that role look like as more and more automation comes into play? What are the career opportunities? Certainly at Black Hills, you know, we have a development team, a software development team, and an automation team that's as big as our docketing team. And they're busy creating rules and configuring the automated systems for automated docketing. So what kinds of opportunities like that are going to be out there, and how do you prepare yourself for those types of opportunities? I think it's going to be a really cool program. I am not speaking on it, so I'm not plugging myself. I just think it's going to be a really cool program, and I encourage everybody to sign up. We have a couple minutes. I want to take a minute to see if there are any questions. I don't see any questions in the queue, but we'll just give everybody, and Z, if you want to go to the, or Michelle, I'm sorry, if you want to go to the next slide. Give everybody a minute for questions. And while we're doing that, one of the questions is, can I get a copy of the previous recordings? Michelle, can you let people know where those recordings are available? They can go to the SLW website, right?
Yes, absolutely. So if you go to the Schwagman, Lundberg, and Wissner website, which is listed at the bottom of the screen here, slwip.com, and then you'll look for a place that says SLW Institute, and there you can find all kinds of webinar recordings, slides, blogs, all kinds of helpful resources.
Good. We had, let's see. I have a question, and I don't know, maybe Ellen or Z, I don't know if you'll be able to answer this, but it relates to FIP and expiration dates. When calculating an expiration date, does FIP automatically calculate from the priority date? Does it know when not to use the provisional date? I know that's a fairly complex function in Foundation IP, and I don't know if you guys are able to speak to that or not.
So it is very specific to FIP, and right now they're doing like that earliest priority date, and some people are entering information from the provisional, and that's incorrect because it has to be the first utility application that it claims priority to. So if you enter the incorrect data, it will launch the incorrect expiry date.
Okay, so I think one thing that's important with that is understanding the particular fields in FIP and making sure that you're using those fields correctly, right? And there's guides and definitions available from CPA Global of what the different fields are to make sure you put the right information in the appropriate fields for those calculations, correct?
That is correct. It's FIP recently added the earliest effective date filed, and that's what it's going to base off of your like expiry date too. So yes, you are correct, Anne.
Okay, I see a question here about asking about some recommendations on docketing systems for sole practitioners, and we'd be happy to talk to anybody about that. And actually, if we go to the next slide. So for that person, I'd like to give you Jim Brophy's contact information. Before Jim came to Black Hills IP, he was in the business for many years selling software docketing systems, and would be happy to talk to you about those types of questions. And just anybody who might be interested in automated docketing, or Black Hills also does PTA verification. We do patent proofreading. We do maintenance fee and annuity payments. If anybody's interested in any of those services, please reach out to Jim Brophy. If you're interested in the Schwegman Lundberg Wistner law firm, please reach out to Michelle. We'd be happy to talk to you about any of those things. Okay. So I think we're at the end of our hour. I appreciate everybody's time today. I hope you enjoyed this program, and have a great day. Thank you.